I don't know. There we go. Good afternoon. Welcome to the Board of Adjustments, 1:30. We got a quorum. I'm going to go ahead and call the meeting to order. First item on the agenda is the minutes.
I'd like to make a motion to approve the minutes.
Got a motion. Do we have a second?
I'll second.
Got a motion and a second. Cast your votes.
Still signing in.
We're all signing in.
There we go.
Who moved and who seconded?
Oh,
Somebody down there?
Roberto, I think, moved and Don
I second.
Nobody knows what right of the way.
Still signing in. Still loading. Sorry.
Okay. Somebody moved, okay.
Yeah.
Okay, we're good. Continuance requests and withdrawals. Cindy?
So we have item number 16, case number 15361 was deferred to July the 20th. And I have a new request of item number 6, case number 15259, continued to July the 20th. And item number 7, 15263, also continued to July 20th.
Okay. Is there anyone here that wanted to address the board on those three items? Okay, I think we're ready for a motion then.
Mr. Chair, I'd like to make a motion to approve the continuance requests and withdrawals as read.
Second.
Motion and a second. Cast your votes. All right, those three items are
6 and
continued.
Number 6 and 7.
Do any applicants want to request a continuance? I don't have anything on the consent dockets. So Cindy, I think we're ready to start the first one.
Okay, we have item number 1, case number 15397, request of Drew Cunningham on behalf of Diamond Trail OKC LLC for a variance to the maximum height regulations in the R4 residential, R1 residential, located at 4396 Northwest 36th Street.
Hello, thank you. I represent the owner of the apartment complex at 4396 Northwest 36th Street. My name is Drew Cunningham. The variance we are seeking today is a variance of the height restrictions on these buildings should they be destroyed by fire or tornado. These buildings, 10 of the apartment buildings are currently 2 stories tall. They are legally non-conforming. They were built in the 70s. In 2007, the zoning ordinance changed. And all we're seeking is permission to rebuild them as they currently are at 2 stories and no taller should they ever become destroyed and need to be rebuilt. Any questions? Or?
Questions from the board?
And the reason why they're not in conformance is because of changes that have been made since they got built to today.
The reason they're not in conformance is the zoning ordinances were changed after they were built.
Okay. And it's because they're within certain footage of single family, R1.
They are within, the limit is, let's see, they are within 60 feet of surrounding properties that are zoned R1. And if that is the case, the restriction is 20 feet or 1 story. And they currently exist at 2 stories. So there's 31 different buildings in this complex, and 10 of those buildings are within the 60 feet boundary of surrounding R1 property. And the reason for the request, just to give some context, the reason for the request is the buyers of this property underwrote the property based all their analysis on a certain number of units and the ability to produce income on those numbers. And if a tornado or fire came and destroyed some of the property, then the economics totally change if they're not able to rebuild the number of units.
And maybe another way of doing this would be through a PUD, if they rezone the entire property. Yeah.
Any other comments? Oh, go ahead, sorry, Sarah.
Sarah Welch, Planning Department. I suppose, yes, a SPUD could be used to establish a different building height than the zoning code, but it would be the only variance. I mean, we don't usually recommend a SPUD in lieu of seeking a variance for something that's eligible, so.
Any other questions, comments from the board? I don't have anybody signed up to speak on this one. Is there anybody who wants to address this application? Okay, guess we're ready for a motion.
Before we make a motion, I have a question for council. When it comes to conditions for unnecessary hardship, how do we interpret that in terms of doing this ahead of what could be an issue, since it's not an issue right now?
I understand what you're saying, but what he is anticipating is things that happen in Oklahoma all the time, tornadoes, fires. But the statute is clear that these are the reasons that you could grant the variance. So each of you would review those statutory standards and decide whether or not this applicant met them. Of course, the applicant is free to assert whichever thing they think that they need to assert, but it's up to you all to see whether or not they met the standards, and they, of course, are in your statutory standards section of the staff report. So if you review those and determine that those standards have been met, then it would be appropriate for you to approve the request.
I could potentially address it or attempt to address it. I reviewed that statutory requirement, and my position would be that this is the minimum necessary to alleviate the hardship, because we are only seeking permission to rebuild at the current height of 2 stories. We're not seeking permission to be able to rebuild at 3 stories or 4 stories, which would be more than is necessary to alleviate the hardship. So the hardship is we couldn't rebuild what has existed since the 70s, and the minimum variance we're seeking to alleviate the hardship is we just want to be able to rebuild what's already there. So we're not seeking to be able to do anything else than what already exists there. We're not seeking to turn this into skyscrapers or 5-story buildings at all, just rebuild what's there.
When was the property itself, when did it transfer ownership into the current buyer?
That's a good question. I attached the deed with my application. It was probably within the last 2 years, probably within the last year, honestly. I think it was within 12 months or so from at least when I filed this application.
If we grant this variance, is it tied to the property itself or to the applicant, to the property?
It runs with the land.
I put a few different times in my application, really the appeal that a hardship would be presented in the event of a fire or tornado, because the available amount of units to this population in the city would be reduced by, I think there's about 10 units per building, so that's about 100 units total. So a hardship would exist for those people who lost their homes and couldn't find available space because the total available units would be reduced.
I understand the premise of just trying to rebuild what's currently there. I do find that, to echo Marcus's question, and where I think he was headed, it seems like a little bit premature to seek a variance on something that has not occurred as of yet. And so, a lot of times we're anticipating rebuilding these because something has happened. In this instance, nothing has happened as of right now, and there's nothing to guarantee that a fire or a tornado will go through that area in the next 50 years. And so I think that's where Marcus was headed with his questioning. So I do feel like that's a little bit unique from the most applications that we get seeking something that's currently needed.
I agree with your position. However, this process takes time in itself. It's been, I'm not sure when I filed this, maybe 2 months or so, but when things are trying to be rebuilt, timing is everything, and so we just don't want to have to face a delay in the event of a crisis such as fire or tornado. Just having a further 2-month delay before you could start construction is just not something that, just trying to be proactive.
Yeah, I completely get the motivation behind it. My concern is that it's going to create a slippery slope in terms of people speculating. I don't want to use variances, or I don't want people, the intent is not to use a variance to effectively rezone. And outside of some conditions that exist that force us to address a current issue, that's the way I interpret it. These guidelines are in place. If this building had been destroyed or 60% of it had been burnt up by a fire, my position would be different, because the way that I view this and interpret it, I'm not seeing a hardship right now. If there was some natural disaster or something like that, that would be different. But I think granting a variance on something like this, to me, opens the door that anybody that's looking at a particular property that's subject to either a particular zoning code or an overlay can simply say they don't want it and find some prospective issue in the future to base a claim for a variance on it. And I just personally don't think that that's what the variance is intended for.
I don't think it's a speculative anticipation of just some unknown issue. It's when you have a property such as this that's legally non-conforming, and it conformed to the code when it was built, and then subsequent to that, the zoning changed, a buyer in that situation, especially a commercial property, is seeking assurance that what they're buying is not going to be diminished due to factors outside of their control, such as fire or tornado. A lot goes into decisions to buy property of this nature. Lenders have requirements, underwriting requirements, so it provides a mechanism to assure those types of people who are going to come in, develop, operate, maintain housing units. It allows them some assurance to know that their investment criteria can be relied upon and not be totally blown out the window, for lack of a better term, in the event of fire or tornado.
I completely get that. The flip side of that coin, though, is that the city has a responsibility to provide some predictability in terms of zoning and infrastructure, architecture, what's going to be built in a given area. And that's the reason why these guidelines exist. So I'd ask you to look at it from the perspective of an adjacent property or a neighboring property owner that says, here are the current guidelines that's in place. I can have some relative assurance, just as you're talking about your investor wanting, that says this is what's going to continue to be built here. I'm not saying that I would be against it, again, in a scenario where it's actually happened, but by granting a variance today, what we're effectively doing is robbing another board the ability to examine this under the circumstances that exist at that time. So if this happens 50 years from now, we would have tied their hands when they can look at this and make a determination at the appropriate time.
Well, I would counter that by saying the developer who initially built this in the 70s was robbed of their ability to rebuild what they built initially when the zoning laws were changed in 2007. So you can look at it from both ways. Either the city's going to change the zoning laws and the property owners are going to have to deal with it, or the property owners can seek a variance like this and have some assurance that, at least barring future changes to the zoning code by the city, which I assume they could still do after they grant the variance, both parties here are going to face changes. In this case, changes already occurred in 2007 after the property had been built for 50 years at that point. So that's the argument we would say from our perspective. And it's housing, affordable housing that people rely on. It's not, manufacturing facility or some, retail shopping center. It's just apartments. So it's something I think we can all agree is vital, and there's a shortage of in the city. So it's valuable to the city to be able to maintain at least the number of units that exist now. It's hard to, I'll just leave it at that.
Were the purchasers, the buyers, were they not aware that it was the restrictions of the R1 designation when they bought the property?
I can't really speak to that. I don't know the timing of when at which point in their due diligence did they discover this. I assume, I know that this has been done before, at least maybe not before this board, but it's a large institutional buyer, and they've sought these types of variances before or after closing. So I think it's probably fair to assume they knew it before they bought the property, but I can't speak to that with certainty at this moment. I don't have the records to be able to answer that.
It just seems a little bit unique, or I guess interesting, that they bought the property, and I feel like they're now doing some of the due diligence after the fact rather than before the fact. And just like any residential buyer where they had to buy a piece of property and they're subject to an HOA, they're on public notice, on record notice that those HOA bylaws had been filed. It's not like this was hidden somewhere.
Right.
So I feel like they bought without going and getting all their information prior to signing on that dotted line.
Well, there's just always a lot of factors at play in timing on transactions like this. The banks have the guidelines. The buyer and the seller have agreed to a certain period of time to accomplish certain items. So there's always going to be time constraints, and this process in particular takes a really long time. So I don't think that, I think they made a calculated risk probably in assuming that this type of request to maintain the status quo would be approved, and they had other time factors at play. I understand the concern about setting a precedent for a slippery slope of people just speculating. I get that for sure, and you would want to prevent that, but I think the board always is going to look at these cases, or always has the ability to look at them on a case-by-case basis, and it's not like in district court where you're publishing findings that are binding and set precedent. So I think the board could rule on this today and know that they will always have the opportunity to review each one of these requests in the future individually and make an informed decision on a case-by-case basis. And I would also just point out that there is nobody who received notice who came to contest it, so that speaks at least to some level of the pushback that we would expect from residents.
Any other questions or comments?
One last thing. If this is denied and becomes the norm that these types of things are denied, one could argue that it will just have a chilling effect on buyers of this nature who want to invest in the city, maintain, buy, operate affordable housing units like this or any other commercial property. That obviously the city has a huge incentive in encouraging people to come in and make productive use of the land. And if those people don't have the type of assurance that I'm seeking now, that could have a chilling effect on buyers, investors, developers' appetite to come in and take on these types of projects.
I struggle with this because, again, I think I'd have different questions if you were here seeking a variance for a building that needed to be rebuilt. But given the way that it currently stands, we don't have the ability to, I don't have the ability to grant a variance to something not knowing what the conditions, the site conditions will be present at the time that this does become an issue, if it ever does. So a lot of this is based off of context and harmony, architecturally speaking, from what the neighboring properties. And so to make a decision on this, to grant a variance to this right now, not knowing what this site looks like, who knows how many years from now, that's really at the heart of the issue. So I get what you're talking about in terms of assurances, but again, that is a two-edged sword.
We're seeking to rebuild a two-story apartment complex, and there are two-story single-family homes sprinkled all throughout the neighborhood, the surrounding neighborhood. So 1-story to 2-story homes is nothing. 1-story to 2-story apartments is, we're not going from, industrial to retail or single-family to multifamily. We're going from single-family apartment to two-family apartments, where there's two-family apartments, or two-story, single-family homes sprinkled all throughout the area.
Yeah, but that argument is valid today because you can review what's there and speak on what's there today. Neither you nor I can speak on what's likely to be there in the future. And, again, along with that, legal non-conforming, I mean, that's kind of the definition of it, is we can't make assurances on that. If I have property that has a legal non-conforming use or architectural style, that's to, somebody else made the point earlier, in the due diligence, that's one of the things that I'm considering ahead of time, is knowing that I'm not going to be able to enjoy the same benefits that were bestowed whenever the zoning changed. So you talked about the original builder, being robbed of the ability to build it back the same. I think the city has a history and a record of basically, this is the way that we make that even, so to speak, for lack of a better term, is the city doesn't come in and require that something be made conforming now. It's got that grandfather protection that's built in, but that's about as much of a balance as we can make, if that makes sense.
Anything else?
No, thank you.
Okay. Do we have a motion on this? Anybody ready?
I don't know about you gentlemen, but based off of the fact that we talked about the speculative nature of this matter, I can't put forth a motion to approve this particular one, so I'm not sure where you guys fall. Otherwise, I can make a motion to deny the application.
That's where I'm at.
So, okay. Motion to
Sarah Welch, Planning Department. I was just asking the applicant if he's interested in converting this application into an SPUD, but I think if you actually make a decision on the application, we wouldn't be able to transfer the funds to a new SPUD application. So I just wanted to look to our attorney to see what other options they would have.
Are you suggesting that he continue this item
I
and then
would-
later withdraw this?
I was just wanting to preserve that option just in case he was interested in that, because once you decide it, he'd have to start over with a brand new application fee. So you could continue it into a certain date, and then when that date approaches, if there is a SPUD application in process, we would withdraw this item.
Yes, that sounds like a great idea. I would like to continue this, pursue a different course.
To what date?
Just onto the next agenda is, if I have, when that is off the top of your head?
Well, July 20th is our next agenda for continuing.
Sure, till the next agenda.
Okay. right, now we ready for a different motion.
All right, motion to continue case number 15397 to the July 20th agenda.
Okay, motion and a second. Cast your votes to continue.
All right, thank you.
Okay.
Thank you.
Item number 2, case number 15410, request of David Box on behalf of Griffin Media Center OKC for a variance to sign regulations in the DBD Downtown Business and DP Downtown Parking District located at 100 West Main Street. And we had a previous meeting today. The DDRC approved the application with the following condition, that the applicant obtains a variance from the Board of Adjustment for the maximum allowable sign area regulations.
Good afternoon, David Box, 522 Colcord Drive, here on behalf of the applicant, Griffin Media. This is for a variance for the logo 9. If you're familiar with the building, when it was owned by Opubco, there was a large electronic sign that wrapped around the building and faced both south and to the west towards the Colcord. Griffin has taken over. It's now the headquarters for News 9. And they have removed that digital billboard that wrapped around it and replaced it with a digital billboard that just faces straight south. Even though this isn't what I think some would consider a traditional sign, it's a mesh material, it's not lit, it really blends in and hides that parking garage under the code. It's considered a sign. It is in the DDRC, so we were required to go to the Downtown Design Review Committee this morning, who, with a vote of 7-0, approved the CA and provided a recommendation of approval to this item. The staff report that I'm not sure if you get from the DDRC was also of a recommendation of approval. So staff had no objection, recommended approval, as did the DDRC. Happy to answer any questions.
Questions, comments from the board? I don't have anybody signed up to speak on this one. Is there anybody who wants to address this application?
And there was no one here this morning either.
Just out of curiosity, how much does the current sign vary from the actual sign regulation? That is the 150?
Approximately 150 feet. One of the problems is when you are looking at signage calculations, it's in total. And so you can see kind of next to the trees, you have Griffin, you have that sign. Everywhere there's signage counts against you. So in total, it's 150 square feet over. I would argue that this one really kind of blends in and frankly is not much of a attraction like the other signage is, but by strict definition of the code, it is a sign.
Ready for a motion?
Motion to approve case number 15410 for the purposes that it meets the statutory requirements for a special exception. The sign regulation, sorry, I'm so used to my regular spiel.
We're used to dealing with home shares.
I thought that's what I came to, was the home sharing board, but I forgot it was the Board of Adjustment.
For a variance, yeah.
Yeah.
So just to be clear, for the purposes of that variance to the sign regulations pursuant to that case number. Based on the purposes that it meets the statutory requirements for that variance. Thank you. Take 2 meetings off and I forget how to conduct a meeting.
Thank you.
You're approved.
Item number 3, case number 15414, request of Prairie Surf Media for a variance to maximum allowable sign area and time limits on super graphics in the DVD downtown business district located at 1 Myriad Gardens. And we also had a meeting today, and they voted to provide a recommendation of approval to the Board of Adjustment for a variance from the time limits on super graphics and a maximum allowable sign area regulations contingent on a time limit of the end of calendar year of 2025.
I, Loudon Baker, 1 Myriad Gardens, staff representative of Prairie Surf Media. Firstly, I want to say thank you to the board and thank you to Cindy for your facilitation of today's meeting. Yes, so to sort of give you a little bit of the impetus as to why we're requesting this signage, we're looking for a way to better communicate to our community and our visitors sort of the valuable industry that's located within our facility, as well as provide a visual anchor point to let people know that these high impact, high valuable, high quality productions are taking place within our walls downtown, as well as facilitate an opportunity for community engagement and excitement as our Oklahoma film industry is thriving and we would be taking part in celebrating that buzz as a state. The signage as well is located in places where temporary signage has been located in the past to promote things like concerts or Cirque du Soleil performances, etc. We're looking for the opportunity to sort of have these variances to where we could continue to bring in signage that reflects the current projects, productions, high-value stories that are coming through the facility. So they would continue to rotate as our projects and our facility rotate.
Did you say this went through DDRC as well?
It did, yes.
Okay. And they didn't have any problem with it?
They approved with a contingency of maintaining it to our existing lease, which is currently set to end, I believe, December of 2025 with an option of 3 years through 2028, dependent on both parties.
Can you recall the vote?
It was unanimous.
I didn't have anybody signed up to speak on this one. Does anybody want to address the board on this application? Yeah. Anything else from the board?
You're not? You're
I
ready for
can't
a-
make a motion.
Okay, no, I was making sure you're ready for one.
Yeah.
Motion to approve case number 15414 for the purposes that it meets the statutory requirements for a variance as requested for the variance to the maximum allowable sign area and time.
And would you clarify in your motion the time frame?
Limited to, I think you had mentioned that earlier the vote limited this variance to the term of the lease, is that correct?
That was the recommendation, yes.
Okay, and we will follow along the same path there. Thank you.
All right, motion was second. Cast your votes. You're approved.
Thank you.
Item number 4, case number 15412, request of Ryan Huggins for a variance to primary access regulations and lot width requirements in AA Agricultural located at 19321 Southeast 134th Street.
Give us your name and address and tell us about your application, please.
Yes, my name is Ryan Huggins. Currently live at 3700 Notting Hill Drive in Moore, but own 20 acres at 19321 Southeast 134th Street. This is my wife, Ashley, pregnant with our twins, and those are our 2 boys, Liam and Everett. We purchased this 20 acres a few years ago, have been saving, dreaming of moving our family out to that acreage. We acquired an express easement of 25 feet from our neighbor to the south. That photo doesn't show it. I didn't think about printing massive poster boards, but I have some other pictures here if y'all like them. But we spent about $30,000, countless of my own hours of my own time, constructing a nice driveway to this property. We purchased a mobile home to live on it. We called the city ahead of time, even when we were in the process of purchasing it, and they said, as long as you've got a 25-foot easement, you're good. But when we applied for the building permit, we were told by the building permit individual that apparently we would need a variance to deem our 25 feet access easement and private access drive as acceptable according to the city. We have an easement filed with the county, and he said as long as we had that, all we needed was a variance in order to allow that to be deemed as appropriate access to our property. To briefly address the statutory standards, acquiring more land to actually touch a public roadway isn't really a possibility. Our neighbors aren't willing to sell us a sliver or anything. This is obviously kind of a peculiar situation, and this variance would grant relief by simply allowing access through where we already have a legal access point filed with the county clerk. We have a great relationship with that neighbor, and that's currently how we access our property. This is the minimum remedy for that because it's already approved and it's already currently in use, and there aren't any issues with that. So we'd be super appreciative if y'all would grant that variance so that we can get a mobile home moved out there before our twins get here. That'd be great.
Okay, questions, comments from the board?
I do think that this is particularly the type of scenarios for which variances are intended to be used. I do have a question though on how we got here. Did you purchase this from the property owner to your south?
No, it was just a property owner that just had the property, and I don't think they ever went to it, honestly.
And do you know how long it has existed in this configuration?
I really don't know.
I only ask because the city maintains a process, so they maintain a deed approval process, which I'm assuming you already tried to do that through planning because you don't have the minimum frontage. But in lieu of that, acreages that exist in these landlocked formats that I think we don't even allow them to, we've got an administrative process that keeps it from happening now, but I think the ones that slipped through are old enough that they qualify for an exception, but that's something you'd have to find out from planning, but that's neither here nor there since we're here today, so it makes sense.
I want to say we missed it by like a year or so.
Okay. I think
I
it's like
we missed the
70s
window,
or something
yeah.
like that. If it was
Yeah.
cut up in that time frame, it's an automatic approval, but I was just curious.
I don't have anybody signed up on this one. Does anybody want to address the board on this application? Okay, guess we're ready for a motion then.
I'm just curious, I'm looking at the pictures. Are your boys tired from helping in the construction phase?
Hey, Liam, do you remember when you helped us build that road? Hey, Liam, was that a tiring day? You remember how hot that was? They were great helpers.
Well, I'll put forth a motion to approve case number 15412 for the purposes that it meets the statutory requirements for the variance as requested in the application.
Okay, motion and a second. Cast your votes when you can. There we go. Approved.
Thank you so much.
Item number 5, case number 15386, an application, special exception of table property management on behalf of Adam Grover and Kayla Jean Diedrich to allow home sharing in the R4 and HL Historic Landmark at 305.5 Northwest 25th Street.
Hi guys, we are seeking approval for this to be a short-term rental.
Just for the record, give us your name and address again.
Oh, I'm sorry, Alyssa Dyer. My address is 1316 South Youngs. Here seeking approval for 305.5 Northwest 25th to be a short-term rental. I was here a couple months ago seeking approval or received approval for the downstairs unit of this duplex. I think the only information that is not on the packet, because it's a recent decision that might be helpful, is that we are adding So there's two duplexes, actually that picture is helpful. So there's two duplexes that kind of share a driveway that diverge. So we're adding a couple parking signage pieces to the back so that guests know that their spaces are on the left of where those trees are. Everything else in the packet should be accurate.
Anybody have any questions on this one?
Is this a one-bedroom, one-bath unit? And you're asking for one guest. Is with the parking situation, would you allow just one car? And then, I don't know that you mentioned quiet hours in the application, but
Yeah, we do quiet hours on all of our properties from 8 p.m. to 8 a.m.
In your listings, you'd specifically note that there's not going to be any on-street parking?
Yeah.
Okay.
Yeah, and on this particular street, they will get a ticket from the city because there's a actual no parking on the street in front of it.
You've got 5 years in here for the special exception, but this is the first time that you're offering this as a short-term rental? This
Yeah,
particular property?
we had a long-term tenant who was there for a long time, and so he gave notice and moved out a couple weeks ago.
I don't have anybody signed up to speak on this one. If anybody wants to address the board. Okay, I guess we're ready for a motion then, if there aren't any other questions.
I'm sure you're pretty used to our process. I think since this is the first time for this one unit, that we'll do a 1 year, but motion to approve case number 15386 for the purposes that it meets the statutory requirements for special exceptions with the modifications to the application. The quiet hours shall be from 8 p.m. to 8 a.m., no on-street parking for a term of 1 year.
Okay, motion and a second. Do we have a second? I'm sorry. There we go. Cast your votes. Okay, you're approved.
Thank you, guys.
Item number 6 was deferred. Item number 7 was deferred. Item number 8, case number 15395, an application of Susan Owens to allow home sharing in the R4 residential district located at 2504 Thornberry Lane.
Hi, my name's Tara Billiou. I'm representing iHomes and Susan Owens today, and we're requesting a special exemption to make one of our current long-term rentals a short-term rental for home sharing.
just a couple of questions about the property. It's a 3-bedroom home.
Correct.
How many baths?
It has 2 full baths and a small powder bath.
And you're requesting 8 to 10 guests?
It had, so one of the other properties that we have that's a 2-story, the upstairs bedroom has 2 full beds, so 4 people can sleep there. But most of our, when we advertise it, we only advertise for up to 6 guests.
Would you be
Honestly, we filled this application out in January, and that was before we started kind of doing things and getting our stuff advertised on Airbnb. So I did that then, not knowing that really how we would need to put it. So our actual ads will just show up to 6 guests.
Okay. Would you be willing to put that in the application, just a maximum of 6 guests?
Yes, yes.
And then as far as cars, a maximum of 4 cars? And
Yes, 4
no
cars
on-street
easily
parking?
fit in the driveway. Yes.
Right. And then other thing, quiet hours?
I think we have listed on ours from 10 p.m. to 6 a.m.
And then the other thing is, it being the first time the property's up, a 1-year exemption.
Okay. So in a year, we would just come back to, okay. And then at that point, it might be an option to do perpetual?
Yep. I say perpetual, we can give you more years.
Okay.
Anything else from the board? Because I don't have anybody signed up to speak on this one. Anybody want to address us on this application? Okay, I think we're ready for a motion.
One quick thing on the quiet hours, I think 8 a.m. is usually what we like to go up to. So I'm going to make a motion including 8 a.m. So if you would be able to revise your listing accordingly, that'd be great.
We can, that's not a problem, thank you.
A motion to approve case number 15395 for the purposes that it meets the statutory requirements for special exceptions with the modifications to the application that this shall be limited to 6 guests. Quiet hours shall be from 10 p.m. to 8 a.m. for a term of 1 year.
Motion and a second, cast your votes. You're approved.
Thank you.
Item number 9, case number 15396, an application of Susan Owens of iHomes LLC for home sharing in the R1 at 10344 Exeter Avenue.
Same situation. This is a property that we will, would like to get the special exemption so that we can advertise it as a short-term home sharing as well. And I'm sure the application says the same thing. So the same things that you guys just asked, that's not a problem to amend those. Because I think that I probably put up to 8 guests on it, and the quiet hours, we just kind of used as standard. So that, neither of those things are an issue for us to amend.
Questions, comments from the board? I don't have anybody signed up to speak on this one.
There were 2 protests, written protests.
Oh.
We'd like for you to, or I would like for you to reach out to them just to communicate with them.
Okay.
If you could.
Did those come through? I haven't seen. Susan may have gotten them and they didn't make it to me, maybe.
They would be in the packet.
Okay. Perfect, thank you.
And the house is basically the same size, 3-bedroom.
It's a 3-bedroom. This is a 2-bath, 3-bedroom, 2-bath. It has a fenced backyard. It sits on a corner lot.
Okay, anything else from the board? Nobody signed up to speak on this one, so I guess we're ready for a motion.
Motion to approve case number 15396 for the purposes that it meets the statutory requirements for special exceptions with the modifications to the application that it shall be limited to 6 guests, quiet hours from 10 p.m. to 8 a.m., and for a term of 1 year.
Okay, we got a motion and a second. Cast your votes. You're approved.
Great, thank you, guys.
Item number 10, case number 15407, application for special exception of Nisha Bailey and Keith Rogers to allow home sharing in the R1 Single Family District located at 6820 Northwest 118th Street.
Hi, my name is Keith Rogers. Address 9010 North Hassett, Oklahoma City. The address for the home share is 6820 Northwest 118th Street. Was my primary residence for almost 9 years. We're applying for a home share, Airbnb.
Okay.
How are the beds arranged, the sleeping in this property?
I'm sorry.
What is the layout of beds?
4-bedroom, 3.5 bath. There's upstairs, there's 2 bedrooms. One is a bunk bed arrangement for children. There's a single bedroom on the other end with a full bath. And then Downstairs, there's like a mother-in-law plan in a cabana, master bedroom, master bath.
So you've got double occupancy for 3 bedrooms and then 4 people in the upstairs with?
Yes, I'm sorry, there's double occupancy in the cabana, double occupancy in the upstairs. There's 2 full bunk with a trundle. There's, going off memory here, sorry. And on the upstairs, on the other end of the room, there's a double queen, master, and then the cabana's a double as well. So,
The main house is a 3-bedroom?
correct. So the fourth is the cabana.
And it's detached and,
It's a detached building, yes. It's kind of like a pool house kind of arrangement. Has a separate detached, well, I say it's detached, there's a tunnel. It's a separate foundation, I'll put it that way. The upstairs is connected. So it's kind of they call it a cabana on the floor plan.
So you've got 2 people can sleep in the cabana.
Correct. It's a queen-size bed.
And how many bedrooms are upstairs in the main house?
In the main house, there's 2 bedrooms upstairs.
And you can sleep 2 people in each of those?
There's the 1 bedroom, is another queen, 2 people. And then on the other end of the room, of the top upstairs, there's a bunk bed for two full-size with a trundle under it.
And how many bathrooms are in this house?
There's 3.5. There's the master upstairs, the one private bedroom has its own bath, the half bath downstairs, and the cabana has its own full bath.
Mr. Chair, I know there's 1 written protest. Did anybody sign up to speak on this?
Don't have anybody signed up. Is there anybody who wants to address this application? And you got 1 written protest. Did you?
I have some paperwork to talk about that if you want to cover it, if it's not needed.
Mr. Rogers, can I just confirm with you that you said that the cabana was detached or attached?
Well, I'm not an architect, but it's a separate foundation. The upstairs is connected to that cabana building. When you look at the house, there's like a portico that goes between the 2 buildings. Does that help?
Yeah.
Do we have anything else from the board?
I think that the sticking point's the maximum number of guests. I think that's why the line of questioning. I think
Okay.
that we could probably all get on board. Definitely for 8. Anytime that you ask, in addition to 2 guests per room, that's why we start inquiring. It's like what's actually going on. But I think that if you would be willing to accept 8, then I think we're ready for a motion. I think if you're wanting more than that, I think we'd probably want to know a little bit more as to the basis. What's your feel on that?
I mean, if it's a stipulation to get the approval, I think we can work with that. I mean,
I would possibly, because it will be for 1 year, so a year from now you'll be coming back. I think that if the first year goes well, and maybe you can provide a little more clarification on the spacing and everything.
Gotcha.
I'm not going to speak this to the other board members, but I would reconsider possibly increasing it by at least 1 or 2. I mean, sometimes that makes the world of a difference. But just to let you know, I think that's kind of what we're asking as to the bed situation. We've had applications here where they've requested 22 people in one home, and it's kind of like, wow, what exactly? And so I feel like you're cramming people into a space by that point.
Yeah.
So if there's nothing further, I can make a motion.
I think we're ready. Nobody's wanting to address.
All right, motion to approve case number 15407 for the purposes that it meets the statutory requirements for special exceptions with the following modifications to the application. Application shall be limited to 8 guests. Quiet hours shall be from 10 p.m. to 8 a.m. and for a term of 1 year.
Thank you.
Motion and a second. Cast your votes. You're approved.
Item number 11, case number 15408, an application of special exception of Letitia Major on behalf of Brett Roberts of Home Away LLC to allow home sharing in the R4 district located at 11500 North May Avenue, apartment 302.
Hi, I'm Letitia Major on behalf of Brett Roberts with Home Away. You want my address?
Yes, please.
It's 2501 Demote Drive in Yukon, Oklahoma. And then the address we are applying for this for is 11500 North May Avenue, apartment 302 in Oklahoma City. It's a 1-bed, 1-bath studio condo. I believe it's 473 square feet. We have a 2-guest max with a designated parking lot. I want to say our quiet hours are 10 p.m. to 7 a.m. That's what I wrote down here, so I think that's right. We've been a successful 30-plus day rental for a little over a year now, and so we would just like to apply for this to kind of fill in the gaps between our traveling nurses.
In the parking lot, are the reserved parking spots?
No,
They're not reserved?
not reserved. And that's just one area of the parking. I mean, it's a huge complex, so there's parking all over. And it's also gated. The only way to get to any units is through the gate into the parking lot.
Now, the application has the address is listed as apartment 302.
Yes,
So is this a condo or is this an apartment unit?
it's a condo. It is the Summit, I think the Summit condominiums. We have 3 properties, so sometimes I get them confused.
Okay.
They are condos. So it might be unit 302, but I think it is apartment.
But it is owned by Homes Away LLC then?
Yes.
Okay.
I don't have anybody signed up to speak on this one. So anybody wants to address the board on this application? Okay. Any other questions or comments from the board? Ready for a motion?
Okay. I will modify your quiet hours from 7 a.m. to 8 a.m., just to let you know.
Okay.
But motion to approve case number 15408 for the purposes that it meets the statutory requirements for special exceptions, subject to the following modifications. Quiet hours shall be from 10 p.m. to 8 a.m. and for a term of 1 year.
Okay, we have a motion and a second, so cast your votes. You're approved.
Thank you.
Item number 12, case number 15409, a renewal of special exception of Brady Salcido to allow home sharing in the R2 residential district at 2319 Northwest 16th Street.
Make sure to take notes this time after last year. Make it a little bit easier so I don't fumble over my words. But it's Brady Salcido, 2680 Yana Street. And we're applying for a renewal of our special exemption for short-term rentals.
And over this past year, we, from the last meeting, we understood there were a lot of regulations, and the board was really trying to restrict and keep to really quality rentals. So over the course of that time, we've maintained a 4.96 out of 5-star rating. We've really made sure to pay all the appropriate taxes. We've had no complaints, incidents, or events that occurred on our property during that time span. We've also been working with the Oklahoma's Department of Tourism, where they've been shooting promotional and advertising videos at our property as well to support tourism in Oklahoma and Oklahoma City. And we understand that short-term rentals are increasing in the city, and they're trying to balance those appropriately. And we believe we've been an exemplary example of running a really high-quality short-term rental and doing it well. We also employ our neighbors as well, so they're a part of our property as well. So we hire our neighbors for our lawn mowing, our pest, and property management and cleaning as well, just to support our neighbors and make sure we're maintaining good relationships in the community as well.
Questions or comments from the board?
You guys haven't had any sort of police calls or anything, citations
Never.
during that time?
Never. Ours is more of a family property, so we have like lots of kids' toys, pack and play, so we don't really get, even though it's a 4-bedroom, the 4th bedroom is like a small bunk bed, so it's really only for kids, so we never get any parties or incidents. And we're very clear with all of that in our house rules and regulations.
Nobody signed up to speak on this one. Does anybody want to address the board on this application? Anything else?
It's kind of nice seeing some of these renewals coming up now. I think that based off of what we've done in the past couple of months is for renewals to extend that period up to 3 years and see how the next 3 year go.
That's fine.
So I just want to let you know in advance. I didn't see anything as far as I do see in your self-imposed rules. It's not after 9 p.m. I want to at least put something in the morning. So just to let you know, I'll put 8 a.m. in my
That's fine. That's fine.
in my motion. But if no one has anything else, I motion to approve case number 15409 for the purposes that it meets the statutory requirements for a special exception, subject to the following modifications. Quiet hours shall be continue to be from 9 p.m. up to 8 a.m., and this shall be for a term of 3 years.
Got a motion and a second? Cast your votes. You're approved.
Thank you guys so much.
Item number 13, case number 15411, application of Bethany Locke for home sharing in the R2 Medium Residential District at 2205 Northwest 22nd Street.
Hi, I'm Bethany Mobley. I reside at 2950 Orlando Road, Oklahoma City, 73120. And I'm requesting a special exception for home sharing at the location 2205 Northwest 22nd Street. Our house rules will include quiet hours are 9 p.m. to 8 a.m., no street parking. We have a noise monitor that is used to monitor noise above 80 decibels during the daytime and 75 decibels during quiet hours. A Ring video doorbell monitors the entrance to the home, and we use operations software to standardize the departure, cleaning, and we have inspectors that go to the home before each guest arrival to ensure that it's first guest feeling. So.
It's a 2-bedroom home?
Yes.
How many baths?
I'm sorry?
How many baths?
1 bath.
1 bath. You're asking for 6 guests. How do you
Yes.
arrange the 6?
1 bedroom has a king bed, 1 has a queen bed, and then we also have a fold-out sofa that folds out to, I think it's a queen size.
And you don't allow street parking, so a maximum of 3 cars?
Yes, correct.
I got one. Have you seen this?
I have not.
Okay, and make sure, yeah, this is on yours. Cindy, do you have another copy, or is it?
No, I just saw that in there.
Okay.
She can have that one if she wants.
Okay. I'm going to show you, as long as Cindy's got another one.
Did you want to speak on that, or?
Pardon?
Did they want to speak on?
Nobody signed up on this one, so.
Yeah, oh, sorry.
Does anybody want to address this application? Okay, they're just the one protest that came in an email.
Would you like me to address it?
Yes, please.
Okay.
Yeah, we don't have it.
We are planning to do it as a short-term rental and also do a long-term rental. I was under the impression a long-term rental does not fall under, I guess, this request. I think that's what the email is addressing.
Yeah.
And I'm happy to talk to Linda.
Okay. Anything else from the board? There's nobody here to speak on this one. I guess we're ready for a motion then.
Okay. Motion to approve case number 15411 for the purposes that it meets the statutory requirements for a special exception, subject to the following modifications to the application. Quiet hours shall be from 9 p.m. to 8 a.m., and this shall be for a term of 1 year.
Thank you for your time.
Hang on, we're going to vote. Now you're approved.
Thank you.
Okay, item number 14, case number 15389, a renewal of special exception of Gina Buenadev to allow lodging accommodations in the R1 and the UCD Urban Conservation District located at 1602 Northwest 21st Street.
Good afternoon, Board. My name is Joseph Buendia. I am here representing my wife who filled out the application. She's the host of our property. We're actually have the next two properties on the list, items 14 and 15, and I'll specifically talk in regards to the first property at 1602 Northwest 21st Street. My personal address is 2712 Drakestone Avenue here in Oklahoma City. Cynthia, should I let them see this packet as well? We don't believe our full presentation got added, but our next one's on there. So that has some pictures of the property and our house rules and descriptions of our goal with our properties. We are actually applying for a renewal for a special exemption for home sharing license. We've had a home sharing license for the last year. My wife is a super host status and has a 4.99 rating for this property. And we've had guests come from all over the world and have repeat guests. And what we've tried to do is, replicate what my wife and I have seen on our travels around the world and around the country. We try to stay in really interesting areas of cities where there are walkable neighborhoods. And this property in particular is 2 blocks from Oklahoma City University and 4 blocks from the Plaza District. It is on a corner lot on 21st Street and McKinley. It has a white picket fence around it. It's a 1917 home that's been completely remodeled. It is 3 bedrooms and 2 full baths, and it has a driveway that will accommodate 3 vehicles and also has a 1-car garage that we do let the guests use. And the configuration of the bedrooms, we have a king-size bed in the master bedroom that has its own ensuite bathroom. And then we have 2 additional bedrooms with a full-size bed and 2 twin beds that share a full-size bathroom. Laundry on the property and a front porch and side porch and back porch. As far as I know, we haven't had any complaints about our property. We have neighbors that are adjacent to us to the south that we've become very good friends with, and they may have sent something on behalf of their experience with us over the last year. And I would request a renewal for license for 3 years if possible.
Questions, comments from the board?
You've had no complaints during this past year? You've had no complaints with the police or anything like that?
No, sir.
Okay, and I don't have anybody signed up on this one. Does anybody want to address the board on this application? Okay, nothing from the board. I guess we're ready for a motion then.
Just to be uniform within all these motions, as far as the morning, if it's prior to 8 a.m., I'm going to try to keep it consistent and modify that. So I think that's the only modification that I want to make to your application. Thank you for answering on the years, because it didn't look like you had specifically listed any number of years. But I think, like I said, based off of our experience, that 3 years sufficient or is worthy to be granted. But motion to approve case number 15389 for the purposes that it meets the statutory requirements for special exceptions with the following modifications. Quiet hours shall be adjusted from 10 p.m. to 8 a.m. and this application shall be approved for a term of 3 years.
Got a motion? There's a second. Cast your votes. You're approved.
Thank you, Board.
Item number 15, case number 15387, a renewal application for special exception of Gina Buenade for lodging accommodations in the R2 and HL overlay Jefferson Park Urban Conservation District located at 324 Northwest 26th Street.
So this is our other property we'd like to present. It is at 324 Northwest 26th Street. It is in the Jefferson Park District. Again, we bought this property 2 years ago. We have been running it for the last year. We have a 5.0 star rating with, I believe, 70 plus guests. We have several repeat guests, and we're approximately 2 blocks walking distance from the Paseo District, 1 block away from Cheever's Restaurant, and several walkable areas that my family and I like to enjoy ourselves, and often we stay there with our kids overnight as well. The property is a 3-bedroom, 2 full baths, and has a long driveway with a detached garage. We have in our master bedroom, we have a king-size bed with its own master bathroom. And the other 2 bedrooms have a queen-size bed and a full-size bed, and those share a full-size bathroom. We have a living room and a full kitchen and a backyard, and plenty of lighting throughout the property. We also have a noise property management software that we use called NoiseAware, and we've found that we live in an area that is quite busy and with close neighbors, and we really wanted to be able to at an instant be able to know if anything else is going on the property, just as if someone came to the door and our Ring doorbell notified us that there was a package delivered or someone was entering the property, we would know if there's a certain decibel level of noise in the backyard or around the property that was exceeding our house rules. On our street, most of the homes are all single-family homes, and directly behind us on the south side is a backyard to a duplex, and then directly behind that yard is a small multifamily unit apartment complex that also has upstairs balconies with tenants to stay there as well. We are requesting for this to be for 5 guests. Last year when we went with the board, we had agreed on 5 guests, and we actually liked the small number of people for the property, even though we have 3 full bedrooms. But 5 guests allow us to keep the number small, to cater more towards families. And we've had lots of requests for people to try and bring more guests during the day, or even for more to stay. And my wife is very strict on not allowing that.
Any questions or comments from the board?
I did want to mention that in your staff report, I did indicate that there was a historic preservation meeting on 6/8, and they made a recommendation to the Board of Adjustment on failure to receive a certificate of appropriateness for work completed, and as a result causing an adverse effect on the character of the property and district, and they recommended a denial.
Could I speak to that? So last year when we went through the same process, we first went to the board for the Historical Preservation Committee, and they also denied us a recommendation. And so we met with and followed all the rules. We talked with the supervisor who went to the property. He talked with my wife, who said, "You guys have the nicest house in the neighborhood, and I'm going to close your account out." There was no citation or fine in regards to that, and that was immediately following our meeting with the board. A week and a half ago, we got a citation with a $120 plus fine, which we had no notification about. We called the office, we called the person that we spoke with last year, and he told us that he did not understand it, but he was told by his supervisor that something had to be done. And then we called his supervisor, and he said that he wasn't sure about it either. And so we're a little bit of a loss why we got a citation after the case was closed last year, even though we followed all the proper rules to get it addressed and to try and get it taken care of.
I think we got somebody wants to speak.
Yeah, Katie Friddle, Planning Department. I can't speak to what happened on the code enforcement side because that's development services. So if they had a notice and it got closed out and then reopened, I can't speak to what happened with that. But what the commission was commenting upon is that there's visible work that has been done to the property that is not in kind, it doesn't match the historic condition, and it was done without a certificate of appropriateness and without any building permits. I can't tell you right now whether anything that was done requires a building permit because we haven't reviewed it, but it certainly is work that would have required a certificate of appropriateness because it's a change to the exterior of the property and the site. So that was what the recommendation of denial was based upon.
Okay. Questions for Katie?
I've got questions. Have you read through the protests?
Yes, my wife and I have.
Okay, do you have any response to one of your protesters was very thorough and detailed, leaving a date log and even some times that instances occurred where there were issues at the property. Can you address any of those?
Sure, and my wife is happy to come here and talk because she has spoken with Mary, who's here today, who's our neighbor.
We actually did not receive a copy of the protest, but I did see it on the video from last week. So thank you for listening. We had, about a year ago, I did receive our neighbor Mary's protest letter, so I did get to see it. I was to be honest, very surprised by her, what she wrote at first, because she said that I refused to meet with her, which was not true. And I look back at our text log, and we had met on my front porch, and we had discussed what a short-term rental would look like next door. And we had also talked about she had discussed how she was thinking about making a change in her employment, and that she is a chef. And we talked about maybe collaborating, and she would provide chef dinners for our guests, and we could create something kind of working together. So I left thinking that it was going to be a good situation. I did not know that she didn't feel that way afterwards, but said that I had not applied for licensing, but I had applied for licensing because we had received a notice that we were incompliant, that we had not applied. But when I called to check just to see the status, they had found my application. I have always replied to her and to a guest if there was ever an issue. And I looked at my phone just to see, like, did I miss something? In case I missed anything. But I looked back at the guest replies. I have been very conscientious. I want to protect our home. I want good quality guests there. We require a deposit now for people to stay. We have more of an upscale Airbnb. The people that are staying at our house now, they are in town for a horse show for 2.5 weeks. So typically these are repeat people. They're quiet, they stay there. But there has been an instance that we did have a guest that was very disrespectful to the rules. They were going to a party on the same street, not at our house, but they were bringing people back in. And that did happen, and that was something that Mary had discussed. And I had replied to the guests. And so there are things that are definitely being addressed, and I don't want things to be, I don't want it to be uncomfortable for her. I don't want it to be uncomfortable for the guests that have been staying at our house. And I have had a guest say that she yelled at somebody one day because they had parked, and I had requested that they park their car in the street while our lawn care people were blowing the leaves and cleaning. Oh, I'm so sorry. Had blown the leaves so that it could kind of clean up our yard temporarily. And then I had written her just to make sure that she knew that it was me that asked them to do that, and it wasn't them being disrespectful, being on the street, because we don't allow people to park on the street. So.
Did you guys actually receive a citation for no CA? Did you end up going to court?
No, we've
Did you pay a fine?
We did just receive one, yes. But a year ago, no. We received a notice. I called and he closed it out.
Okay.
And then whenever I called again to see what the fine was about, he had said that, or the lady that I spoke with on the phone said that this has been closed, but you have a fine, and that you would need to address that as if you were receiving like a traffic ticket. So I called another person down that was recommended to me. I've talked to like 3 different people, just because we want to do the right thing and we want to make sure we're going down the right avenue. So that we're.
It's the exact same, it's a citation for the exact same thing that got closed out last year. So that's what's confusing to us, because we were told it was closed out, and then we got the citation, it was for the exact same thing that we were told was closed out. So I guess we're just trying to figure out that part of it. We want to do the right thing, but we're just confused about it.
Katie Friddle, Planning Department. I did check with code enforcement with an inspector earlier today, and he said that the previous citation was closed out in error. Now, I don't know if that was a mailing. I don't know what the error was, but that it was closed out in error, and a new citation was issued May 9th of this year, and just says exterior changes without certificate of appropriateness.
And that one hadn't been addressed yet. or resolved yet, correct?
Correct,
Okay.
yeah.
Okay. Now, does anybody on the board have questions? Because I got one person signed up to speak. Okay. Mary, you signed up to speak? Come on up. Give us your name and address and
Mary Granger. I live at 328 Northwest 26th Street, which is right next door to 324.
okay.
I'm the one that wrote the letter, so you know my complaints. As you know, Gina Buendia was approved for a special exemption to operate a home share as non-residents of the neighborhood. They did not apply for this exemption before they opened their doors as an Airbnb and were given a notice of violation pending application and approval for the special exemption. They also, in this conversation that Gina's referring to, she told me and the other neighbor that she had already applied. And when I wrote to find out if we could weigh in on this, we were told that she had not made an application. I'm here today to report as the neighbor most affected by this business that it indeed disrupts the quiet family neighborhood we have enjoyed for 11 years. There's no doubt that Gina is wonderful about, she's a wonderful hostess. She's very adamant about her rules, but you have the list of the things that have happened in spite of that. She has no control over those things. My husband and I no longer feel comfortable if there's late night noise there at 2 o'clock in the morning. At first, we would go and knock on the gate and say, "Can you please take your party inside?" And they usually were nice about it. But we got 2 responses, clearly drunk people singing in the bathtub, in the hot tub, that made us feel uncomfortable about doing that. We didn't know what would happen, what kind of people these were. There are lots of cars coming in and out. Yes, there are families, there are wonderful families, but almost nobody ever says hello to us. The neighbors on the other side who've lived there in that neighborhood for over 40 years, their biggest complaint is that we don't have neighbors. We don't know who these people are that are coming. We don't know how many cars are going to be. Sometimes they're parked on the street, sometimes they're not. And we have all of the loud landscaping equipment that goes on various trucks coming in. It's a business that's right next door to us, and I'm just here to say that I don't think that that Airbnb belongs in our neighborhood. The amenities outside in the backyard invite parties. I mean, if I paid for that, I would want to use it too. And that's what that is. We call it the party house in our neighborhood.
any questions for Mary Granger from the board? Comments?
I've got a question for the applicant. You said that on each of these instances you responded to Mary, because there's a couple where she says that there was no response. Is that not accurate?
When I look back at my text messages, I responded to everything except for one last one, but I had responded to the guests because it was pretty late. So I didn't message Mary, but on everything else, yes, it's a text thread that I want a good relationship with my neighbor, so I will respond, and I don't want them to be disturbed by people in the night if that happens. But yes, there was everything except, and I look back because I thought I've always responded to her, but I did respond to the guests at the last one. So,
And then
that was in February.
The instance where you did have the guest that you stated that was just not respecting the rules, how was that handled? Was that short-term rental canceled early? What action was taken?
It was on the last day of their stay. They ended up having to pay a fine because they broke all the rules. They also will never be able to come back. I wrote them a negative review. I don't like doing that typically, but in this case, I wrote them a negative review. All 5 stars. So that's one thing we always put on our prerequisite for people to book, is they must have all 5-star ratings. But they were attending another party, and it was not at our house, but they were disrespectful. So that did happen, but that's not the norm. I mean, the norm are people who are attending horse shows, and people who are in our home for a while, and families, and people who are coming in for softball games. And that is the typical norm of the guests staying at our home, not the person who was disrespectful to Mary and to our home.
And we do have the ability to monitor noise instantly now, which we did not have when we applied for the license last year, because we've had some guests that have stayed at our home that Mary had complained about, and when we asked the guests, they said, well, the people that are behind us, and if you look at the picture, there's the apartment complex to the south of us, and then there's a duplex behind us. Well, there's people there that sometimes sit on their balcony and play music, and my kids and I have sat in the backyard and we can see them, and we've heard them play music. And but you know, we've never complained to them about the sound and things, but we do understand that we want to keep the quiet rules regimented and followed. And so now we have the ability with 100% certainty to tell if the noise is coming from us, it will show on our monitor. And it won't be the person across the street or behind our backyard or the apartment complex or the duplex. So we're really trying to do everything to be, continue the tranquility of the neighborhood, because we do love the neighborhood a lot.
We had our cleaner came one day to our house, and she called me right after, and she said that she spoke with Mary, and that Mary was asking, well, what's going on back there? It sounds like there's a party. And no one was staying at our house, but they said it was very loud, but it was coming from the property behind us. And that was something that I didn't realize was happening as often. And it does sound like it's coming from our backyard, but it's really not always our backyard. And so,
There was another instance where she said she didn't get a response regarding a truck that was blocking the city trucks from emptying the trash bins.
mhm.
Did you respond to that?
I did. I responded to Mary, and and we had a long text going on about it.
And he did move his vehicle into the driveway.
He moved it. He works in Oklahoma City from Dallas, and he parked his truck in the street. He apologized, and he moved it immediately. So it got taken care of, and I did respond to her. I looked back just to verify, but we had a long text thread going about that truck.
Well, the reason that I ask these questions is this, I can't speak for anybody else, but for me, this is the one issue that my decision really hinges on. I cannot force you to only lease to guests that wave and say hello to Mary. I can't force you to rent to people who are kind and happy neighbors. But I do think it's our responsibility to make sure that you're managing the property in a way that ensures that the people that you place there are not going to detract from the lives that the neighbors are living. And if I'm honest, I'm seeing some of that here. There's two parts to this. One is, an event taking place in the first place, whether it's a party or whether it's somebody parking in a way that precludes a trash truck from getting through. But the second is the response. And so I'm glad to see the times that you have responded to her, but it's also not her responsibility. It's not any of the neighbors' responsibility to manage the property. I'm glad to hear that you guys have the noise monitors in place now, and that those are there so that you can be more proactive. But I don't want to have a scenario where you guys have to react to what she said, where she has to always come to you and say, hey, there's this issue. Because while I completely understand that you don't control the actions of the people you lease to, she certainly has even less control than that, because she doesn't even get to choose who gets to stay at the property. So those are big things, and I've stated it here publicly, and I want to be consistent. Management is really the biggest thing that I look towards. Maybe it's something that you guys can talk about in the future as far as maybe having a property manager or somebody else that may make her feel more comfortable, that may make it a easier transition, somebody that can respond faster. I don't know what the solution is, but it cannot be one where the onus is on the neighbors to respond or to reach out to you to respond to issues, particularly when there are several of them.
When did you guys install the noise detection device that you have?
So it's this past winter when we had
It was after. It was like right around the time of that.
we had some,
Those guests.
that episode, and we had some moms that were in the backyard, and it was 10 o'clock, and they were out there talking, and so we responded and told them that we have specific quiet hours, and after that, we put the monitor in place, which,
Okay.
so, in regards to management, there's really kind of two major issues. One is noise, two is parking. Our camera on the front of our house allows us to see the small area of front yard that is in front of our house. So every time a guest comes in, we can see if they park there. There have been numerous times that probably nobody's had that addressed, where someone was in the front and we called them or messaged them and said, you need to park in the driveway. There's absolutely no parking in the street. And so all the times that we have taken care of things may not be talked about here, but this is an actively managed property that we take a lot of pride in, and we really do try to take care of the neighbors, the guests, the property. We have the lawn maintained every week. We have had some complaints that when they come in and have their leaf blowers going, that it's a little loud for our neighbors during the daytime, but we can't control like maintenance of a few things like that. But we really are. We're really actively trying to make the neighborhood beautiful and maintain the yard and that. So in terms of actively manage, I don't think, Gina really takes a lot of pride in that hostess and the hospitality and trying to create a great space for everybody.
So in our packets, we do get recommendations, and the recommendation on this one's to deny the application until you acquire that certificate of appropriateness. I don't know if denying, I don't want them to have to refile, but can we postpone this matter until, I'm not sure how long it takes to get that certificate. So is it better to postpone, to move out to a later date?
You could do that, or you could do a conditional approval so that it's approved if they bring proof that they have received a certificate of appropriateness.
Okay.
So that would never issue until they complied.
Okay.
Or you could continue it and have them come back here.
We are happy to get their certificate and apply for that. We just were under the impression it was closed. So just until last week, we did not know.
And the people we've talked to have been confused about it too, to be honest. So it puts us in a bad spot because we could have got it taken care of, and it kind of popped up on us in this last week and a half.
And I'll tell you, for me, I would request that you continue this. I want to follow the actions of the other board. I want to know that that's getting taken care of prior to approving the application.
Do we have a timeline on what that process looks like?
So it will depend on Kitty Friddle, Planning Department. It'll depend on what the work is that actually requires a certificate of appropriateness, whether that is all work that we can administratively approve. If so, we're looking at just a couple of weeks. If it's work that has to go back before the commission for review, then that's more like a month to 6 week kind of process. And if they've done work that the commission cannot see their way to approving and has to ask them to make changes to the work already completed, then that's potentially a longer process. But could certainly be something that you all continue to, not so distant meeting, and we could at least report back on the status of why the notice was closed out in the first place, what is the work that's going to require a CA, and what that timeline looks like. But as of right now, I don't know enough about the work that's been done to be able to tell you a more specific timeline than that.
My suggestion again would be continue to July 20th and give you a month, and come July 20th, we'll either know more or you'll have your certificate. That's up to you guys.
I'm sorry, does that require us to just come back to the Board of Adjustment meeting again
In a month or so.
in July and go through the process again once we figure out what?
Yeah, well, we want to be mindful of, your fees and the time and everything, so. But unless July 20th does not work with you with your schedule, then we can definitely do the meeting after that. But my recommendation, it would be to postpone it or continue it to July 20th. Okay.
And I'll just say, just for full transparency, I would recommend reaching out and coming to some terms with Mary. I'm only speaking for myself. As the way that the application currently stands, I won't support it unless you're able to get her on board with making her feel comfortable that significant changes have been made.
All right.
There's nobody else signed up to speak on this one. I guess we're ready for a motion then.
All right, motion to continue case number 15387 to the July 20th Board of Adjustment meeting.
Okay, you got a motion and a second. Cast your votes to continue. July 20.
Thank you, Board. Appreciate it.
Item number 16 was deferred, so we're at the end of our docket.
I don't have any additional items. No board committees, comments from board members? Rita, you're next.
No.
Nope. Citizens to be heard? I don't have any other business. I think we're adjourned.